Norman A. Mordew, United States District Judge. Chief United States District Court Judge. Okay. Hello, Sebastian. Okay, this is 11:15. We rejoice at the sunshine. 11:30 we rejoice that somebody is standing up to this crookedness. We rejoice that Mr. Claus is serving the papers as of this moment. 12:45 on November 17th, 2007, Anno Domini. And we rejoice that we're going into attachment 2 pretty soon, in 10 pages. And we rejoice for this grand universe. And we rejoice that we caught them. They committed fraud, and therefore all their rulings are nullities. All of these orders I just read to you are nullities. Fraud cancels. Okay. Volume 2 out of 3, page 51, District Court of the United States. This is not an Article 1 nor an Article 3 court. This is mere dictum. Reserved. Okay, we did that one. Page 53. Zai. Glendora has been deprived of her right to file any motions, but she can still file notices. Here are 2 of them. Notice of appeal with 60-page attachment and notice of admissions of 70 pages. Glendora's findings and charges. Effective failure to deny, and that is 70 pages. Short thought, Glendora charges collusion. Press owes Glendora $83,000. Press gets an A for acephalus. Acephalus means without a head. For acerus. Acerus means a needle-like sharp point, like a pine needle leaf, or tapering to a slender point. Or I guess that's acuminate. An assessant for turning sour, bitter, tart. More do, no more motions. Quote, the truth has caught up with him. He's scared, he's afraid, can't take anymore. Glendora's complaint is the perfectly completed complaint. Mordew and Trees can be sued for violation of the United States Code, the Federal Rules of Civil Procedure, the United States Constitution, the New York State Constitution, and I ask you, what is there left? Glendora is not going to sue them. Reserved. Glendora herein submits all 4 of her papers to this court as if fully submitted herein. Any amended complaint would do likewise, and Mordew, Treese, Behrman, the law clerk, Behrman is a court clerk, have taken the side of the enemy to the USA. Yeah, that means they sided with an enemy of the USA who was Eric Press. Mordew, Treese, 3 papers are ghostwritten, ended Halloween month, October the 9th and 10th. Glendora agrees with what one ghost said to another. Do you know what one ghost said to another? Frankly, I don't believe in people. Mordew, Treese slammed the door shut, standing behind it the same way Press did. Why? Was it the same door? I think so. There must be many of them behind that door. A lot of runaway judges, fugitive judges behind that door. Did they see them? Did they see their newsworthy conduct reported on YouTube? Is more due an accessory to trees? Are both accessories to press? Who can tell us? Glendora still wants her $350 back, together with $30 in White Plains. Both plummet to consumer fraud. It is $150,000 and $17,000 a year. I think Press gets about $70,000, or maybe less, because he's only a part-time judge. I think the judges in the White Plains City Court get about $70,000 a year, and I think federal judges get about $150,000 a year. And they get this to dump as much justice as you can, instead of doing as much justice as they can. They get all this money to dump as much justice as they can, instead of to do as much justice as they can. And this is in violation of their oaths of office, and no immunity, Title 42 United States Code, Section 1983, no grounds to dismiss Press. To Chief Judge, Second Circuit, judicial misconduct complaint. First one to the Judicial Reform Act of 2002, November, codified as Title 18 United States Code 351. It used to be 372. Congress keeps making judicial reform acts, but in 2-3 years they don't do any good, so they make another one. Copy to Press. Let's see, we sent this to whom? Just now it's being mailed, served. Press and the Second Circuit, judicial misconduct. A copy to Mordew, a copy to Treese. The original goes to Mordew. They're all originals, though I signed each of them. And a copy to Mayor Delfino and the White Plains Common Council, who appointed Press. Whatever. And that's it, isn't it? Press, Mordew, Treese. Yeah, judicial misconduct complaint, and the White Plains Mayor and Common Council. All 5 lost their power to perform, abnegated their authority. Today's Bible lesson is Luke 28. God will give them another chance, and maybe a third. And all Glendora has left to do is print her notice and their admissions of fraud and the admissions of fraud, and therefore nullity of rulings, on to Press, Hansberry, Wood, no good Wood in the Yonkers Court, Stephen Tuman in the Phillipstown Court, John Volch in the Harrison Court, Peter Lane in the Rye City Court, Kenneth W. Rudolph in the Appellate Court, New York State, Edward McCabe, Melvin Tannenbaum, John R. LaCava, so-called Supreme Court, County of Westchester, State of New York, and Jonathan Littman, who did such a grand job of cheating. Oh yeah, and Gio Lillo. He did such a grand job of doing things upside down that they promoted him to the appellate division. And Lippman has done such a good job of doing things wrong that he's been promoted to the appellate division, 1st Department, Manhattan. That will be the, I'm going to take a 9x12 envelope and I'm going to write the notice on here. And what will the notice say? You know it by heart by now. The notice will say that you were notified to answer these charges, to either admit them or deny them, and to do so in particularity and specificity. And you did it, and your failure to deny means that you admitted them. One of the things that you admitted was fraud, and fraud cancels everything, and so therefore all of your rulings are null and void. Censorship, ignorance of the law, ignorance of fact, ignorance of procedure. The only things that these law clerks know is federal rules of civil procedure, and how they know it is not to enforce it, but to circumvent it. Does Albany or Syracuse have a pro se clerk, as does Foley Square? Indeed, Foley Square has about 40. About 15, I would say. They have about 15 pro se clerks. A judge, never sees his plaintiff eyeball to eyeball. There's been no court appearances. They call this a court. No witnesses were sworn. No evidence was taken. No testimony was given. No trial. And they call this a court. And they call this an order. Mordew mentions often pro se and shows that he has very little respect for pro se. Well, this pro se has very little to say good about Mordew. And that ends it. Those are the jot thoughts. We are now up to attachment 2, and this is of 70 pages. Attachment 2, District Court of the United States, Northern District of New York, Albany, Syracuse, Part A, case number 07 Civ 0490. Case is Glendora plaintiff versus Eric Press defendant, a judge in the City Court of White Plains. And this is notice of admission to Mordew, Treese, Behrman, and the law clerk. You did not deny Glendora's you did not deny Glendora's findings and charges of Halloween, All Saints' Eve, and therefore you admitted the same, and this is effect of failure to deny. Glendora thanks this court for acknowledging receipt of Glendora's findings, questions, and charges. Mordew, November the 2nd, 2007, page 6 is where they acknowledge it, with request to admit, deny, and give grounds. She thanks you for that. I'm going to read it to you again. The notice. This is a lawful notification and is sent pursuant to the Federal Constitution, specifically the Bill of Rights, in particular the 1st, 4th, 5th, 6th, 7th, 9th, and 10th Amendments, and pursuant to your oath, and requires your written response to the specific to the subject matter. Your failure to respond is stipulated and rebut with particularity everything in this paper with which you disagree is your lawful, legal, and binding agreement with and admission to the fact that everything in this paper is true, correct, legal, lawful, and fully binding upon you in any court in America without your protest or objection or that of those who represent you. Your silence is your acquiescence. Notification of legal responsibility is the first essential due process of law. Silence can only be equated with fraud where there is a legal or moral duty to speak, of which an inquiry left unanswered would be intentionally misleading. By law of effective failure to deny, you admitted Glendora's findings and charges, to wit: Glendora is right about everything she wrote, submitted to you on August the 23rd, in her complaint about Eric Press. You admitted that. You did not deny nor refute any of it. Press committed fraud, ergo his rulings are nullities. You hear again, folks? Press committed fraud, ergo his rulings are nullities. Press perjured his oath to uphold the Constitution, ergo Press subjected himself to the self-executing mandates 3 and 4 of the 14th Amendment of the off the bench and no pension. Press violated Glendora's due process of law. Press violated Glendora's right to jury trial. Press violated New York State Uniform City Court Act, Section 1801 et sequitur, small claims. Press exhibited extreme bias and prejudice. These are all the things they admitted by not denying. Press severely damaged Glendora by taking 4 weeks to sign her 5 subpoenas, leaving only 3.5 days to serve them. He took 4 weeks to sign them, and he left only 3.5 days to serve them before the trial, which he copped out of. The trial was supposed to be on August the 8th. This is all in the year 2007. Press violated the law by not finding nor prosecuting the 5 people subpoenaed for not appearing in court the night of the trial, August the 8th, 2007. Press rankly violated Glendora's due process of law with excessive ex parte. Press violated Glendora's civil rights on Title 40 on 42 counts under 42 of the United States Code, Section 1983, the Civil Rights Act, and 1985, conspiracy. Press failed the requirements of the New York State Constitution, the Bill of Rights. Press perjured his oath. Thereby Press brought on himself the self-executing mandates 3 and 4 of the 14th Amendment, loses his job and loses his pension. Press committed fraud. Press committed 22 acts of fraud. Therefore, all rulings he made are nullities. Press was incapable of dismissing Glendora, a case against Masterilli, Sulaco, and Lewis on the merits fairly and squarely. Consequently, he ran away from the trial. Press violated pro se leniency, Title 28, the United States Code, Section 1654. Anybody has a right to represent himself. Don't hire a lawyer. Press is liable to Glendora for $83,000 damages, compensatory and punitive. We're up to page 6 of the second attachment of 70 pages. Press committed fraud in not ordering Sawrock to show Carmody weight proof of authority to represent Masterilli after Glendora had demanded it over 7 times. So what's it show you? That he didn't have it. And Press colluded with that. Sawrock had no authority to represent Cecilia Masterilli. It was fraud on the court. It was fraud on the public, on you. Press is introducing de Blasi's insane order of 1998 was devious, since de Blasi was debenched for bad judicial conduct, and since de Blasi's law clerk, Schwersky, was declared an agent of Cablevision by the District Court of the United States, Delaware. You admitted to all of the above, plus charges Glendora made against Eric Press. The clerk was wrong to deny Glendora seeing her court file. Paul Friedman, White Plains, Small Claims Court. You see your file anytime. Press failed to be an Article 3 compliant court. Press does not know that a decision by the Appellate Division, the Second Department, Supreme Court of the State of New York is not a law, that judges do not make a law, that only Congress and the New York legislature make a law. Press didn't know this, and you admitted that. Press was wrong not to grant Glendora default judgment against Saraco and Lewis, who did not show August the 8th, 2007, and against Masterilli, who produced no proof of authority of Saroc to represent her. Press was wrong to let defendant open and speak first. Plaintiff opens and speaks last. Speaks first and closes last. Glendora is right that Press should be psychologically examined. You admitted to that. Mordew, Treese, law clerk, and court clerk. By effective failure to deny, you have admitted that Glendora has a presumptive right that a judge should be fully familiar with the facts and circumstances, and that Press was not, and neither are you, Mordew, Treese, law clerk, and Behrman. There are only about 2 minutes left on this tape, and we are up to the second attachment, and we're up to page 9 out of 70. And you have admitted that Glendora had all the proof in her hand that night, August the 8th, to win her case, that Press was wrong to rob her of her trial, and that Glendora had spent 62 hours to prepare for the trial, paid $600 for the subpoenas, and the 5 witnesses, and I paid about $400 for travel, and for Patrick Hanley to go up and get the subpoenas to Susan in Peaksdale and to Cacciola in Harrison. That Press was wrong not to scrutinize Glendora's damnation of hours and dollars that Masterilli caused her, and that he should have awarded her. That Glendora spent $97 travel to go 120 miles and back to the Press court and be cheated out of her trial, August the 8th, 07. We are on page 14 of Glendora's complaint of what you admitted by failure to deny. I'm talking to Mordew, Treese, law clerk, and court clerk. Press did wrong, August the 8th, 2007. You admitted that. You admitted that Press committed fraud by not denying Saroc's illegal and unlawful motion to dismiss when there are no summary judgments in Uniform City Court Act, Section 1801, small claims. There has to be a trial in small claims, no motion practice, and that Press committed fraud in using this motion to dodge the trial, August the 8th. And likewise, you admitted that Press committed fraud in using Saroc's illegal and unlawful motion to quash subpoenas as a fake excuse to ditch the trial, August the 8th. The motion having been submitted to the court day before and not served on Glendora until August the 8th, and not served until 5 p.m., and not served on Glendora until Press directed Saroc to do so. You admitted to all that fraud. You admitted that Press fraud in writing a letter, August the 1st, that August the 8th trial night would be used to argue these 2 phony motions, and that this letter did not reach Glendora until August the 13th, Monday, 5 days after August the 8th. Press writes in a letter, he says August the 1st, it gets to me August the 13th, and it's about what we will do 5 days before August the 8th. Let me say it again. August the 1st, he writes a letter about what we're going to do on August the 8th. Glendora doesn't get the letter until 5 days after August the 8th. Open and shameless, despicable disregard of decency, due process of law, and utter laxity of morals, and you admitted all this? You admitted that the 500 plus pages of testimony that Glendora prepared for the August the 8th trial and that Glendora attached as exhibits to her complaint were illegally, unlawfully ignored by press, and that this was automatically unconstitutional, dis-American, and sinful violation of due process of law, page 11, and affronted the Constitution of the state of New York. As to de Blasio, what jurisdiction does a judge, Supreme Court, Westchester County, have over filing lawsuits in every other county in the state of New York? And a debench judge at that. You agreed with Glendora when she told press in court August the 8th, that's a dirty cop-out. You admitted that Glendora never that Glendora's judicial notice of July the 17th, 2007, to all judges and the clerk of White Plains City Court, pages 20 and 21 of the complaint, which you didn't read, Glendora submitted to you on August the 23rd. The judicial notice that I wrote to White Plains City Court on July the 17th was also submitted to Mordew, Treese, law clerk, and court clerk, Behrman, on August the 23rd. On page 23, you admitted that the New York State Civil Practice Laws and Rules 3211 A7 cannot be used in small claims. You admitted that. And on page 24, you agreed that small claims cases cannot be decided on motion papers. There has to be a trial. You admitted on page 25 that Glendora should